very good morning to Madam and everyone. At this great moment, my team and I take the responsibility to explain the role of federal court in our justice system of Malaysia. First and foremost, justice system originally based on the British one operates in parallel with Sharia courts. There have in recent years been proposals for reform of the judicial system in order to give it more independence from government. The federal court is the supreme court. It is the final court of appeal and it has the exclusive jurisdiction in constitutional matters and in issues arising between states or between the federal government and states. High courts are located in Peninsular Malaysia and in Sabah Sarawak. Appeals arising from the high courts come before the Court of Appeal. Session courts and magistrates courts are located in the main cities and towns throughout the country. These session courts are presided over by a judge and have limited jurisdiction in civil and criminal cases. The magistrates courts also hear civil and criminal cases with more limited jurisdiction. All judges are appointed by the head of state on the advice of the Prime Minister and magistrates by the state authority on the advice of the Chief Judge. So now, in this specific context, we will see the clear responsibility of the federal court. The Federal Court of Malaysia is the highest judicial authority and the final court of appeal in Malaysia. Its decision binds all the courts below. The Federal Court consists of a president styled as Chief Justice, formerly called the Lord President, the President of the Court of Appeal, the two Chief Judges of the High Court in Malaya and Sabah Sarawak, and presently six Federal Court judges. The federal court is heard by three judges or such a great uneven number of judges as the Chief Justice may determine in some particular cases. The federal court has the exclusive jurisdiction to determine all civil and criminal appeals from the Court of Appeal. In civil appeals, a litigant may appeal on a point of law the rejection or admission of evidence in lower court. In criminal cases, appeal may be made against acquittal or conviction or against the sentence on a point of law or fact. Disputes on any other question between states or between the federation and any state based on Article 128(1) of the President Constitution. Other than that, the federal court also can determine any constitutional questions which have arisen in the proceedings of the High Court but referred to the federal court for a decision. The federal court can also give its opinion on the constitution when the YDPA requests for it. The Young di Pertuan account may refer to the federal court for its opinion any question as to the effect of any provision of this constitution which has arisen or appears likely to arise, and the federal court shall pronounce in open court its opinion on any question so referred to it. Other than that only, the federal court has the jurisdiction to decide whether a law made by parliament or a state legislative assembly is invalid because the constitution does not give them the power to make such laws. However, any other challenge to a law on the grounds that it is against the constitution can be brought before any superior court. The federal court also hears appeals from the decision of the other superior courts. The most highlighted thing that each and every citizen should know is the federal court is the final court of appeal in the country. Hence, as a conclusion to this case, that is clear that the federal court is the supreme court in which it has the right to solve cases which are still debatable by any means. Corresponding to it, it's the decision of federal court is considered the final as the case couldn't be appealed anymore.
Hi, I'm SIVANESAN SANMUGALINGAM, And I'm here to tell you a little bit about qualifications, criteria of selection and training of judges to become federal court judges, right? So basically, the federal court presides over the Court of Appeal, and by virtue of section Article 122 sub 1 of the Federal Constitution, the federal court shall consist of one president or chief justice, one president of Court of Appeal, two chief judges for both High Court of Malaya and High Court of Sabah and Sarawak, as well as 11 other judges and additional judges appointed by the Yang di-Pertuan Agong on the advice of the Chief Justice among those who has held high judicial office, right? Only people who have held high judicial office shall be in the running for this position. Now, the judge of a Court of Appeal may sit as a judge of the federal court in the interest of justice, and he shall be nominated by the Chief Justice, right? Now, the Chief Justice is the head of the Malaysian judiciary and also the head of the federal court, the highest court in Malaysia. The appointment of judges of the superior court level is being set out under Article 122B of the Federal Constitution. The Chief Justice of the Federal Court, the President of the Court of Appeal, the two Chief Judges of the High Courts, judges of the Federal Courts, Court of Appeal and High Court, on the advice of the Prime Minister after consulting the Conference of Rulers. So the Chief Justice here plays a very, very big role. Every appointment all the way down to the High Court, even down to the lower courts, session courts, magistrate courts, is done by the Chief Justice, and after he will give advice to the Prime Minister, and the Prime Minister will also consult the Conference of Rulers before giving the advice to the Yang di-Pertuan Agong, who will then make the appointment. Prime Minister, a person is qualified for appointment as a judge of the Superior Court if he is a citizen. So you must be a citizen first and foremost. Second, you must have had 10 years preceding to this appointment. You must have been an advocate for those courts, right? That means all the courts, High Court, Court of Appeal and Federal Court, you must have, worked in those courts as an advocate or a member of the judicial. So maybe you are a judicial commissioner and you have been there for 10 years, or you have been in the legal service of the Federation for 10 years, Department of Public Prosecutor, for example. And the other side will be if you had been of legal service for a state, right? So these are the ways you get appointed to become a federal court judge, or maybe before a federal court judge, maybe even Court of Appeal judge, then become a federal court judge later. A judge shall not be a member of any political party and participate in any political activity. If a judge was practicing as an advocate or solicitor prior to his appointment, then he shall on his appointment cease to have any connections with the firm. So you cannot continue with your legal practice if you become a federal court judge. And all judges in the superior courts retire at the age of 66. And to our knowledge, there are a few judges who will be retiring at the age of 66 soon, and it will be interesting to see how the Chief Justice, who is only 62 years old, so she still can stay, but the Chief Justice can now appoint new members to the federal court, and not appoint but rather advise the Prime Minister as to the new vacancies and how to fill the vacancies, and the Prime Minister will then again talk to the Yang di-Pertuan Agong, getting the consent of the Council of Rulers will then make the appointments, right? So the federal court judge, right, as under the Article 122A of the Federal Constitution, His Majesty on Yang di-Pertuan Agong may appoint a session court judge, and all the way down to magistrate court, all on the advice of the Chief Justice of Malaysia. So it is a very, very powerful role, which basically um, stands supreme over the entire judicial system and appoints all judicial members. Right, it's headed right now by Yang Ahmad Arif Tun Datuk Seri Utama Tengku Maimun Tuan Mat, the Chief Justice of Malaysia, Yang Ahmad Arif Tan Sri Rohana Yusof, the President of the Court of Appeal of Malaysia, Yang Ahmad Arif Tan Sri Datuk Sri Azhar Muhammad, the Chief Judge of Malaya, Yang Ahmad Arif Datuk Iskandar bin Abang Hashim, Chief Judge of Sabah and Sarawak, followed by the 11 other judges that can be appointed. Right? So this is the brief explanation on the criteria, selection process and training of how basically how to become a federal court judge. Thank you very much and good evening.
Okay, so moving on to the jurisdiction of the federal court, but before we dive deeper into it, or before I even say a word about it, I've divided the jurisdiction into 4 crucial parts, namely original, appellate, referral, and adversary jurisdictions. So without further ado, let us take a tour to the first part, the original jurisdiction. Under Article 128, Paragraph 1 of the Federal Constitution, the Federal Court has an exclusive original jurisdiction, which is to evaluate the validity of laws passed by Parliament or by the legislature of a state on the ground that it deals with a matter it has no power to legislate, and resolve any questions between states or between the Federation and state. When the need arises, the Federal Court may exercise consultative authority in its original jurisdiction. The next part is the appellate jurisdiction, which I will divide into 2 elements of appeals that are civil and criminals. For the civil appeals, with the leave of the Federal Court, an appeal against the decision of the Court of Appeal may be brought to the Federal Court under Section 96 of the Courts of Judicature Act 1964. It has to be noted that the leave will only be given if, firstly, the Court of Appeal's decision is in relation to any civil cause or matter decided by the High Court in the exercise of its original jurisdiction, where it includes a question of general principle decided for the first time, or an important question of law on which further argument and a decision by the Federal Court would be to the public benefit. Or secondly, if the Court of Appeal's decision concerns the effect of any provision of the Federal Constitution as well as the validity of any written law relating to that provision, with the duration within only 1 month after the date of the appeal decision, an application for leave to appeal must be filed to the Federal Court. Furthermore, Federal Court is under no need to provide explicit reasons for granting or rejecting leave, and this premise was upheld in the case of Dato' Secretary and Board of Trustees of Sabah Foundation in 1999. In addition, the Federal Court has the power to order a new trial of any cause or matter tried by the High Court. A new trial, however, will not be granted on the ground that the evidence was improperly rejected or omitted. Okay, so for the criminal appeals, Section 87 of the Court of Judicature Act confers the Federal Court the jurisdiction to hear and determine any appeal from any decision of the Court of Appeal pertaining to any criminal matter decided by the High Court. For instance, in a murder trial held in the High Court, any party which is dissatisfied with the judgment can appeal to the Court of Appeal with a further right to appeal to the Federal Court. An appeal may lie on a question of fact or a question of law, or on a question of mixed both fact and law. Where an appeal is presented against an accused, the Federal Court may, subject to Section 88 of the Courts of Judicature Act, issue an arrest warrant for the accused to be brought before it, and may remand him to prison pending the disposal of the appeal or admit him to bail. Under Section 90 of the Courts of Judicature Act, the Federal Court may dismiss an appeal that comes before it. Besides, it may also confirm, reverse, or vary the decision of the Court of Appeal, order a retrial, or remit the matter with its opinion to the High Court. Moreover, the Federal Court can also take additional evidence itself or direct it to be taken by the High Court. For the third part, which is the referral jurisdiction, Federal Court needs to determine questions concerning the interpretation or effect of any provisions of the Federal Constitution that have arisen and referred in another court in the form of a special case. After Federal Court has decided, it remits the case to the trial court to be disposed of in accordance with that decision. The trial court may order a stay of proceedings pending the Federal Court's ruling. Last but definitely not least, allow me to end my presentation today by explaining the last part of the jurisdiction, the adversary jurisdiction. Under Article 130 of Federal Constitution, any question relating to the effect of any provision of the Federal Constitution that has arisen or is expected to arise, Yang di-Pertuan Agong may refer to the Federal Court for its opinion, and the Federal Court shall issue its opinion in open court in the form of a declaratory judgment.
Greetings everybody. My name is FULANTIRAM and I am going to present about the special powers of federal court. In this matter, I will explain an example case where the federal court had to step in to finish the issues which are still debatable among the courts. So in this case, we are going to review the case between Indra Gandhi Muthu versus Pengarah Jabatan Agama Islam Perak. So let's go to the fact of the case. The plaintiff, Indra Gandhi Ananthavamuthu, was married to the defendant, Padmanathan Anlaki Krishnan. Their marriage was registered under the Law and Reform Marriage Act 1976, which discusses matters about civil marriage. The couple had 3 children among them. However, this case unfolds when K. Padmanathan, who was an Hindu, embraced Islam on March 11, 2009 and converted all 3 of their children on April 2, 2009 without her knowledge and consent and with the absence of all 3 of them. He then proceeded to obtain temporary custody order and permanent custody order from the Sharia court for all the 3 children on April 8, 2009 and September 29, 2009 respectively. The 3 certificates of conversion to Islam and a document showing that the register of Mu'allaf which stated that the children were registered as Muslims were delivered to the plaintiff. However, the children were not present during the register ceremony and did not utter the 2 clauses of affirmation of faith which was required in the enactment of administration of the religion of Islam Perak 2004. At the High Court, the plaintiff filed a judicial review application and was granted the order to quash the certificates as they were considered null and void. The plaintiff was also granted custody of all 3 of the children and her divorce petition for civil marriage was granted by the High Court. Upon appeal, the Court of Appeal cited the order and reversed the decision in the favor of the defendant as they concluded that the High Court didn't have the right to deal with matters regarding the Islamic religion. Hence, the legal battle of Indira Gandhi finally reached the Malaysian Federal Court. Now we can see that the Malaysian Federal Court has stepped in to finish the case which is still applicable. So, the parties which appealed against Indira Gandhi 2013 Ipoh High Court victory were the conversion certificates of the conversion certificates of the 3 minors was declared null and void are 6 parties involving the Perak Islamic Religious Department, the Register of Mu'allaf, the Perak State Government, the Education Ministry, the Government of Malaysia and K. Padmanathan himself. The main issue of this case is whether the High Court has the jurisdiction to review the register's actions in which the child, which was below 18 years old, had not complied with the statutory requirements before the register registers their conversion. The other notable issue is the conflict whether the conversion of the child requires consent from both sides of their parents before the certificates of convergence can be issued. Thus, the held conclusion of this case was in January 2018, the Malaysian Federal Court issued an unanimous decision in the favor of Indira Gandhi, which voided the children's certificates of conversion based on a few factors. First, the court opposed the unilateral conversions of the children, ruling that the constitutional right to gain equality requires consent from both parents to change the religion of the minor children. In the context of this case, the Federal Court interpreted Article 12 in the bracket 4A of the Federal Constitution of Malaysia, which stated that the religion of a person under the age of 18 years shall be decided by his parent or guardian, as it requires consent from both parents. Besides that, the Federal Court ruled that the 3 children had not recited the affirmation of faith yet, which was a crucial part of the conversion procedure. Hence, the certificates issued by the Sharia court can be considered as null and void as the procedure was not correctly implied. In addition, the court also ruled that the plaintiff could gain custody of all three of her children.